this is Jane Low, and I'm at Tech Law Fest here in Singapore at Suntec City. And with me today, I'm very pleased and very privileged to have Yeong Zee Kin, who is the Chief Executive Officer with Singapore Academy of Law. Right, so thank you so much for joining us today, Zee Kin.
Yep, thanks for having me.
So you'll be sharing with us on the latest sort of regulatory and legal developments around the world when it comes to AI, which is a topic that is of great interest to many people nowadays with ChatGPT and all that. But before we start, can you give a brief introduction about SAL, which is the Singapore Academy of Law, for our audience who's not too familiar with Singapore?
Yeah, the Singapore Academy of Law is a very unique organization, an institution in the legal landscape in Singapore. Every lawyer who is called to the Singapore Bar is a member of the Academy of Law. So we have, as part of our membership, lawyers in private practice, lawyers who are in in-house legal departments, and increasingly lawyers who are engaged in roles in risk compliance and regulation as well. And of course, we have lawyers who are from the public sector. So it's a good umbrella organization which allows us to convene and expertise, right, and perspectives from very, very diverse spread. We do a few things, right? I think the key ones that will be relevant for our talk today is really two, right? One, which is around professional development, and by that I mean lifelong career development and training. The second is what I like to refer to as the creation of legal knowledge. Traditionally, this has been publication of legal textbooks, but we've gone beyond that. We are looking at precedents. We are looking at comparative law tools, right, that help in-house counsel and a compliance officer who need to grapple with the different laws in the Asia Pacific that they have responsibility over.
Okay, I have a question about how AI will help with upskilling and reskilling, especially in the field of the legal profession, but I think I'll leave that to the last question because I think that is of great interest to many people about job security and all that, right? But before we go into that, I'd like to ask you, today's session, we've seen quite a different number of themes coming up from various panels. There's concerns about, when it comes to AI, concerns about misinformation, about protection for the minors, about biases, all these sort of themes. They are not new, right? And you have been an AI expert for quite some time. And I understand that you sat in the, was it the OECD AI panel of experts. So you have quite an extensive experience, and you have also different hats because you were previously the Deputy Commission at the Personal Data Protection Commission of Singapore, as well as the Assistant Chief Executive of the IMDA, which is the media authority here in Singapore. So you have different hats. So when we look at all these different themes, right, how is it different today versus in the past?
Well, I think that actually the one thing I would draw on is the fact that I have been in this area, technology, media, telecoms law, for over 20 years by now, right? And you're right, the themes don't really change so much. We've always been worried about contents. We've always been worried about protecting children. We've always been concerned about how intermediaries behave. We've always been concerned about data, whether it's info security or data protection.
Right.
We've always been concerned about cybercrime, cybersecurity. I think that the operating environment and the technology has changed, and the changes in the technology brings about different dimensions, right? So, I mean, we use something as simple as let's just talk about content, right? In the old days, and I'm talking about really old days, right? You probably drew something by hand or took a photograph, you scanned it. But these days, you have advanced tools. You can use AI to generate some of these contents. But the point is that if the content, right, is offensive, if the content is harmful, if the content is false, it doesn't matter whether you did it by hand, whether you took a photograph by hand, or you use an AI tool to generate it. You are still responsible. So in that sense, the responsibility and the legal issues don't change that much, but the tool, right, the technology introduces a different dimension. In the old days, to do a fake image, easier to detect because the tools were not so sophisticated, and you needed probably a smaller group of people had the necessary photo editing skills. Today, because of Gen AI solutions, it makes it a lot easier, right? Especially if you're going to talk about deep fakes and all that, right? It makes it a lot easier. So the scale has changed. The ability to detect is a bit more challenging, right? And ability for people who want to play around with this technology, well, it's a little bit more accessible. But ultimately, for every individual, right, the responsibility is still the same.
So I want to bring up, since you talk about images, I want to bring up this case which has also been quite cited today, which is the Jetty versus the Stability AI case. For our audience who's not too familiar with the case, it's really about Jetty alleging that Stability AI uses its images, which are copyright, without permission. Is that right? But there's a lot of complexities around how you actually go around to proving that case. So even though I guess conceptually it sort of makes sense, but legally when it comes to proving the case, there's a lot of operational issues to consider. So I think one comment was, how do you actually prove that those images were used? And all AI models are so complex. So how do you go about addressing all these operational issues? How do you go about mapping the operational issues to the legal sort of framework? That's quite a challenge.
No, I think that is a challenge, right? When you want to bring a claim, right? When you make an allegation, you obviously need to be able to prove, right? And usually in the field of litigation, you want to look for what we call the smoking gun, the piece of evidence that will prove it beyond doubt. But the reality is, very few cases turn on a smoking gun. It really turns on hard work, putting a case together, finding the relevant evidence and piecing it all together and putting up a convincing case. And if you've got good lawyers on both sides, they're going to each try and prove or disprove the case. So I think it makes no difference in this situation.
Right, okay, I see.
So, but I think the interesting discussion around that case is really to what extent if you are able to access copyrighted data, right, copyrighted information, to what extent you can use it to develop your large language models or to use it to train your models. That is an issue that is not new, actually. It's not new. It has been we've been discussing it even before Gen AI. We've been discussing it since we were talking about small models, right?
That's right.
Yeah. So in Singapore, we had a model framework that was put out under jointly by IMDA and PDPC. The model governance framework for AI promotes good practices and good responsible practices so that AI that's produced is safe, it is fair, right? It is human-centric, right? And there's transparency. One aspect has always been data lineage, right? The provenance of the data. Where did you get your data from? Did you get it from a good source? Is the data? Can you use the data lawfully with authority to do so?
Or has it been manipulated or changed in some ways?
So
Before you feed it into the system.
These are very valid concerns. 5-6 years ago, when we were looking at this, right, copyright was a concern, right? If you're using data, do you have the ability to do so? Personal data protection was also a concern, right? If it involves personal data, do you have the necessary legal basis or consents to do so?
That's right. Yeah.
So these issues hasn't changed.
Exactly.
Yeah, but what has happened is that because of some interesting news, right, it has gained some prominence.
Right, I see.
Because some of the large language models that we use today, they use the data from public internet as part of the training data. While this gained a lot of attention today, I want to also say that, again, it wasn't new. A few years ago, there was another case, Clearview AI, right? There's another solution provider. It was a case that was investigated at least by the UK Data Protection Authority and the French Data Protection Authority. The question was, if you have Clearview AI, which is a facial recognition technology, can they go onto the public internet and use personal data in facial images to train their model? Right, the conclusion for both of those investigations was you need to identify a proper legal basis to do so, and both investigations concluded that Clearview AI had not done that sufficiently, and then they were told that then you better make sure this is where you fell short. You need to do more. With Gen AI. It's the same
That's
issue.
the same story, isn't it?
Yeah, it's just that the technology is a bit different. It's a large language model, not facial recognition technology. But same issues have come up, and we have the same learning, right? Which is identify a proper legal basis for you to do so.
Or seek consent, right?
Correct. Yeah.
So talking about the issues being not too different, right? And if we look at what has developed since ChatGPT become so popular, in the last few months, for example, Italy has banned ChatGPT, but then and then they reversed the ban, right? China, I believe, Russia, Iran, North Korea, all these famous countries have banned ChatGPT, right? And how different do you think are the legal and regulatory responses this time to this new iteration of AI versus in the past, or are they the same?
I think that in the initial couple of months there may have been different, I would say, responses and different extents of responses. But I think by now, everyone's moderated, right?
Right, I see. Okay.
Yeah, everyone's moderated. It is generally accessible, but the risks and the issues have also more or less surfaced, and we can identify issues around what we mentioned, copyrights, issues around personal data, issues around leakage of data as you use it, right? So these issues have now become clearer, and I think once we have that clarity, it's a lot easier to start working towards solutions. Yeah.
The conversations have matured, basically.
Definitely.
Okay. So talking about that, right? The EU, looking at the EU AI Act, right? There's references to making sure that your models are transparent. There's you are able to explain your results. Again, those are not new, but it's a lot more complex than say with Gen AI.
I would say that the responsibilities, as you rightly pointed out, not new. With the draft, with the EU AI Act now, right? They are making it obligatory, right, for high-risk systems, right, high-risk applications, and then they have a lower set of requirements for low-risk systems, right? The challenge, as I see it, is that when you talk about fairness, when you talk about transparency, when you talk about repeatability, right, these concepts, they mean slightly different things in different contexts, right? So this is one of the big challenge about regulating AI. The AI is a multi-purpose tool. Used in different contexts, expectations are different. Used in a medical context, expectations much higher, right? And you probably emphasize safety, right? Yeah, and predictability a lot more. Used in a context where personal data is involved in helping to make decisions, you probably want to emphasize bias or rather fairness a lot more, right? And the challenge here is that for generative AI, one of the things that we are thinking about is what does repeatability mean? Because every time you generate an image and every time you generate a summary, it's going to be different.
That's right.
Right? And actually, you want it to be different because that's what you want, right? You want it to be different. So how does repeatability, right, or reproducibility as concepts mean? What do they mean in this context? We have to find different ways of defining it. For example, there will be a tech talk sharing tomorrow, where there's an interesting research, right, paper that has been published, which basically puts out across a proposition that if you can actually use Gen AI to test, to make sure that a document which you expect to have 6 or 7 elements, actually has those elements, right? So in terms of using that as a thought piece, right? When we talk about repeatability for summaries and all these contents, maybe it is that consistency. If you have 4 or 5 elements that must be present, even though the rest are different, maybe that's what we are looking out for instead.
Right.
So the context, so principles will then have to be contextualized so that we are better able to make sure that it's effective for the different types of AI technology.
So if I understand you right, the principles are more or less the same, but it will be more refined for different contextual situations.
Yeah, it will have to be fine-tuned.
Right.
It will have to be adjusted, right? What its representation might look a little bit different, depending on the context.
Right, okay. Right, I'm kind of conscious that we are coming quite close, tight on time. So one last question about job security and, Gen AI and all that. And a lot of people say that there's going to be a big impact on jobs. How do you see it for the legal profession?
Well, the first thing I want to say is that very often people talk about technological job displacements. They always refer to the motor car replacing the horse and carriage, right? I usually want to point out 2 things. Number one, while some jobs were no longer exist, new jobs were created. But the other thing to remember also is that that transition took decades. It didn't happen overnight. It took decades, which means that because we know that some of this is going to happen, we can do something about it. We know that there will be new opportunities. We can start identifying and prepare for it. We also know that this transition takes a while, which also means that it gives us time to put in place the programs to train, upskill, and refocus. And I think that as principles, right, these 2 will apply to any sector where AI finds its way into. Right? The legal sector is no different, and AI has already found its way into the legal sector. So how are we thinking about this? Precisely this, that a lot of these AI tools will find its way onto the desktops, the notebooks, the mobile devices of lawyers. Well, let's make sure that we know they are trained so that they know how to use them. For many reasons, it makes them more efficient, it helps prevent errors, it increases the proficiency and the standard of delivery of their services, and something as simple as clients expect that. So training them on how to use, right? The second one is also about if some of these tools are available, how does it affect the way you train lawyers? Because if the old days, the training was by manual reading of documents and sifting through documents, and if technology helps you cut that down, makes you more efficient, then how are we identifying new methods or developing new methods of training our next generation lawyers so that they are effective? So these things we have started looking at, and we know that there's work to be done. I'll just end off by saying that there are also new opportunities, right? Because AI is coming in, it creates room, right, for legal services to make use of AI. So it creates room for developing those services. Now, once you talk about developing services, right, especially that use AI, then immediately you need legal domain experts who understand legal taxonomy to be part of the data pre-processing activity. You need legal experts who can come in and weigh in and help, right, with the development, providing the requirements. So it will create opportunities that way, and I'm also optimistic that the solutions will help lawyers provide their service in a different way, a much more efficient way than what we are so used of today. It's the kind of transition, right, that between postage, right, posting letters to emails.
That's right, yeah.
Right, and you deliver your service very differently, and you can make use of
Right.
that very
It's
differently.
sort of complement each other, isn't it? The
Yes.
postage and email, isn't it?
Yeah,
Right.
yeah.
And looking at just summarizing in terms of what you highlighted the differences. How the current iteration of AI is accelerating some of these risks, and how some of these new sort of AI legal frameworks have to be relooked at. I think there's no fear for lawyers to when it comes to job security, because there's going to be a lot of opportunities, a lot of demand for lawyers to look at how these are going to impact copyrights, impact our
Yes.
safety online, right? So
And lawyers should be there in front, right?
That's
Helping
right.
with the solutioning,
Exactly.
helping with solving some of these problems. And that way we'll always make sure that the solution is fit for purpose. And that's the way lawyers will always be relevant.
yeah, so I look forward to the next era when we will have smarter lawyers. Not that lawyers are not smart right now, but even smarter lawyers. So thank you very much for your time, Zee Kin. Thank you so much for your.
It's a pleasure. It's
Thank
a
you.
pleasure. Thank you.